Good afternoon, everyone. Thank you for joining us today for a special webinar in conjunction with Hicks Morley, focusing on compliance, immigration and employment amid COVID-19. Today from Green and Spiegel, we're joined by Managing Partner Stephen Green and Senior Associate and Head of Compliance and Inspections, Valerie Kleiman. From Hicks Morley, we're joined by Labour and Employment Associate, Amanda Cohen. The panellists will save some time at the end of the webinar to answer your questions, so please feel free to type out your questions in the pop-up toolbar. And with that being said, I'll hand things over to our panelists.
Good afternoon, everyone. I hope everyone is healthy and well. As indicated by Stephen, we are going to talk about the various immigration issues with respect to people able to enter Canada. And then Amanda is going to talk about various types of labor difficulties that some employers may be experiencing or not really have answers to, and she'll have all the answers for you. So to begin with, let's talk about who can travel to Canada, and does Canada really have a travel ban? Well, I think it's important, first of all, for everyone to understand there are two groups of people with respect to the travel ban. There are people that are currently in the United States and want to enter Canada, and then the rest of the world. And that's the way the ban is broken down. So if you are a person that is located in the United States and wanting to enter Canada, there are different rules for you as compared to other individuals that want to come from other parts of the world, for example, Europe, Asia. There are different rules, and those are the most important things to understand when determining if a ban applies to you. And what the Canadian government did in order to protect us as Canadians and permanent residents was they went ahead and said, there is a ban. No one is allowed to enter Canada currently. And then they said, however, we are going to make some exceptions to that rule. And it's those exceptions that we're going to talk about today, as there are people that are permitted to come into Canada if you fall into the exception. So let's talk about people in the United States. If you are in the United States and you are a Canadian citizen, you are a permanent resident or immigrant, you have the absolute right to come into Canada from the United States by plane or driving across the border. So you have no issue if you fall into that category. If you are in the United States and you currently have a Canadian work permit, or you currently hold a study permit, you have the right to attempt to enter Canada and satisfy the border service officer that there still is work for you if you have a work permit, that there still is school for you if you have a study permit. So what they're doing is they're looking at those people and saying, what is the purpose of your entry, person on a work permit? What is the purpose of your entry, person on a study permit? And if they are of the opinion, that being the border service officer, that your entry from the United States is not optional or discretionary, meaning you're coming here for a holiday or you're coming here to visit, then they will let you in and you will be able to take up your job and continue your studies. Also, the government looked at immediate family members of people that are on work permits, that are on study permits, that are Canadian citizens or permanent residents. So if I am a Canadian citizen and I happen to be married to an American citizen, can I bring my wife into Canada? because that person, my wife, would really only be coming perhaps in a visitor capacity. And I have to be able to satisfy the border officer that my immediate family is not coming under sort of a discretionary or holiday type of purpose. And that could be, I need my wife to be with me to support me during this time, and I'm also there to help her. So you must be able to satisfy the border officer, anyone that is not a Canadian citizen or permanent resident, that you are not coming into holiday in Canada, to vacation in Canada, and it's not for, and the wording they use is optional or discretionary entry. And again, it's the border officer that makes that determination. And it's quite interesting that if you plan on flying into Canada, the Canadian government has given the authority to the airlines to determine many of these characteristics of whether or not you fall within the exception. So are you coming to Canada for a holiday? If the airline feels you are, they will not let you board the aircraft. So it's very important to understand that not only do the border service officers have this tremendous discretion to determine whether or not you fall into that special category that the ban does not apply to you, but so do the airlines if you plan on flying into Canada. And again, everything that I've stated applies to people that are currently in the United States that want to enter Canada. So let's talk about the other group of people, people that are not in the United States, but want to come into Canada. Again, there is a total ban of all visitors, of all people coming into Canada from outside of the United States. However, the government went ahead and made exceptions. The exceptions apply to Canadian citizens and permanent residents. They're permitted to come into Canada. And immediate family members of Canadian citizens and permanent residents. People that are on work permits that currently are holding one, or that are currently in possession of an approval from an embassy abroad, are permitted to come into Canada and ask the border service officer for permission to come in. However, visitors, people that have the electronic travel advisory, they are not permitted to come in if they are coming to visit. So there are no visitors permitted to enter Canada. But the extra component that a person must do if they are outside of the United States and want to join someone that's on a work permit in Canada, join a Canadian citizen, join a permanent resident, and they are an immediate family member of that person, they must get a special letter from the Canadian Embassy or High Commission abroad saying that they are permitted to enter Canada. So that's the big distinction between people that are inside of the United States and people that are outside of the United States. If you do not hold a valid work permit, valid study permit, if you are not a Canadian citizen and not a permanent resident, but you want to come into Canada because you believe you fall into one of the exceptions, you must first get approval abroad from one of the embassies to enter Canada. And again, you will have to satisfy the airline that you meet all those exemptions. And then you must satisfy the border service officer when you arrive inside of Canada. So that's the two distinctions. And you see, yes, Canada has a ban, but there's quite a lot of exceptions. Once you are at the border in Canada, be it the airport, if you've flown in, or be it through the United States, then the rules are the same for everyone with respect to quarantining. Again, the government of Canada wants to make sure that COVID-19 does not expand inside our borders. So everybody now who is coming into Canada must first be in possession of a non-surgical mask. So they approach the border, they approach the border service officer at the airport or at the border, and they must be in a possession of a mask and wearing that mask. If you are not, then the border officer will not deal with you. Then the officer will ask you, okay, I'm satisfied that you meet the exceptions to the rule. The ban does not apply to you, but you must quarantine inside of Canada. And to quarantine inside of Canada, you have to have a plan. The border service officer is going to say, where are you going to stay? And you have to say, I'm going to stay in my own place. I'm quarantining myself for 14 days. They're going to say, well, if you're staying at your own place, how are you going to get food? You have to be in a position to say, I am getting my food this way. If you need pharmaceuticals, how are you going to get that? How are you getting from the airport, if you are flying, to the place where you're quarantined? You cannot take public transit. So you have to have a very detailed plan to satisfy that border officer. Otherwise, they will not let you in and you will be prohibited from entering, despite the fact that you meet one of those special exceptions to the ban. And it's also important to understand that you cannot stay with someone that's considered vulnerable. And what do I mean? Let's say a Canadian citizen is married to an American citizen, and that person, the Canadian, is 65 years of age and is in Canada, and now the American wants to come and join her or his husband or wife. You have to have special permission from your husband or wife because you are 65 years of age and the government considers you a vulnerable person. You must be able to satisfy the officer that you have the special consent of that vulnerable person. And that even applies to situations where people may be unfortunately under, there may be a family member in the house that's under chemotherapy, where their strength is very weak, their immune system is very weak. You would not be permitted to go into that home and quarantine with that person. The government will not let you. So it's very important that everyone understands that you have to demonstrate to the airline, then to the border officer, that you meet the exception to the ban. You have to be wearing a mask when you are interviewed trying to enter Canada. You have to have a quarantine plan available for 14 days in order for you to enter Canada. So that is the current situation. And again, the situation is changing really almost every day or every other day. So the advice that I'm giving you with respect to the ban could be very different the next day. So please make sure that you check with the authorities, you check with your lawyer, check with people that are familiar with the system, because you don't want to be in a situation where you show up at the border, the rules have changed from what they were yesterday, and you're not permitted to enter. And what's happened now, because the government is so concerned about COVID-19 being able to expand inside of the borders of Canada, and they also want to make sure that temporary foreign workers are protected that come to work in Canada, they've amended the rules dealing with compliance. The compliance being that a Canadian employer must make sure that they treat their temporary foreign worker properly. And now Valerie's going to talk about that.
Thank you, Stephen. So all employers who have employees on employer-specific work permits, so the company's name is on the work permit, is subject to Canada's compliance regime. And this includes people who have LMIAs and people who don't, like intercompany transfers and NAFTA professionals. And the compliance system has existed for some time, and employers are routinely inspected to make sure that they're paying their workers properly, that they're respecting the conditions of the LMIA and work permit, basically that they're doing what they told the government they would do before the person arrived. So just as of last week, the government has expanded the compliance system and included new regulations to cover some of the new realities because of COVID-19. So before all of this, we would generally see inspections that were random. This was very often, they would randomly select companies or companies where there was suspected non-compliance or previous compliance issues. The government's now created 2 new triggers to launch a compliance inspection. One being situations where you have a workplace where there's a spread of COVID-19 among workers, or someone has become sick at that workplace, or scenarios where a foreign worker is required to respect an order under the the Quarantine Act, just as the order that Stephen mentioned, the requirement to self-isolate for 14 days when you arrive in Canada. So now employers have some new requirements. They have to, first off, very important, make sure that they're not doing anything to prevent the foreign worker from respecting any orders that they're required to follow. So that's the orders under the Quarantine Act, the Emergencies Act, or any provincial legislation that's relevant. So an employer who forces an employee to leave their isolation and show up at a workplace within the 14 days could be seen as violating that condition. The other key factor is they want to make sure that workers' wages are protected during this 14-day period. So employers are required to continue to pay substantially the same wage as what was promised to the foreign worker during that 14-day period. For employers who have other obligations and have to provide accommodation to foreign workers, and this is generally for streams like the agricultural program, there are additional obligations. So making sure that employees are split up, quarantined and non-quarantined foreign workers, that there's appropriate cleaning supplies to ensure good hygiene, and that appropriate steps are made to separate any workers that develop any COVID-19 symptoms. So these new requirements are effective as of last week, and now Service Canada needs to be notified when a foreign worker on an LMIA arrives in Canada. They have to be notified right away, and they're going to be launching these inspections, which will be very different from the usual inspection. They're going to be completing them within much shorter periods of time, 48 hours, and it'll be a virtual inspection. And as with our normal inspections, there are penalties for non-compliance. So generally speaking, when an employer is subject to an inspection, the officer will look at the violations and they will use a system to determine what penalties are applicable. Some of the penalties include fines, warnings, being barred from using the temporary foreign worker program or the international mobility program, having LMIAs or work permits revoked. So these are just some examples, but there are circumstances where employers can justify and provide legitimate reasons for being non-compliant. So maybe there was an error made in good faith. Maybe there were economic conditions that affected everybody, and even the Canadian employees had some differences. So there are different scenarios where the government will look at some justifications, but it's very clear from these new changes that for the 14-day period, they're going to very strictly be looking at wage and making sure that public health and public safety is first, and that employers are cooperating and participating and playing an important role in that, because people are going to be entering and crossing the border into Canada. So these are some of the new compliance features that we're going to see play out now and see how the government deals with these issues. So I think now what we're going to do is look at a few different issues that employers and companies are facing, and look at the sort of the employment law consequences and the immigration compliance consequences to look at how these issues are playing out in this situation. So I'm going to turn it over to Amanda.
Perfect. Thanks, Valerie. So as a starting point, I think we'll talk a little bit about some of the kind of, I guess, staffing effects or staffing options that people are considering in light of COVID. So it's no surprise that one of the corresponding impacts that we're seeing is that there's either a decreased need for staff, or there's financial kind of impacts on the company that are impacting your ability to kind of continue with the same staff that you normally have. So normally when we talk about that, we're talking about, okay, is there ways to keep staff in work and to subsequently reduce our costs? Or correspondingly, are we dealing with a situation in which we're going to have to place people on layoff? So starting with the first kind of group, that's generally broken down into two situations. So you have certain circumstances where employers will consider compensation reductions. And essentially a compensation reduction would just be kind of an across the board decrease in the salaries that you're paying to employees. Generally, we would encourage people to do it such that it is kind of an across the board equal thing, or at least across the board within a specific employee classification. And that avoids situations in which you're going to be accused of implementing differential treatment based on specific employee groups, which could always be potentially kind of problematic. And generally, you would see the same kind of percentage decrease across the different groups who are going to be affected. Obviously, anytime you're talking about situations in which you're going to be decreasing your employee's salary, the risk that we're talking about is as constructive dismissal claims. So essentially, similar kind of process to a wrongful dismissal, but an employee would say that the terms and conditions of my employment have changed such that they no longer exist, such that you've actually terminated me. The case law on this kind of essentially sets out that the threshold for a constructive dismissal claim would be a decrease of around 10 to 15% in salary. So it's not a hard and fast rule. It's not that the second you go over 15%, you're in constructive dismissal territory. But the case law generally tells us that if you are kind of within 10 to 15, you're more likely to be in the safe zone. And then reductions in hours or reduction in work week really is the same concept from a kind of employment law perspective. The only difference is that the change in salary corresponds to an actual change in the hours that the individual is working, right? So it may be that you have a setup where employees are working Monday to Friday, regular kind of days, and you decide that on a go-forward basis, employees won't be attending at work on Fridays. And so not only would they not be paid for the Fridays, but they also wouldn't be required to work for Fridays. From a practical perspective, that's sometimes hard for salaried workers, for example. It may be difficult to actually track the hours they're working, in which case it ends up just kind of coming back to being a compensation reduction. And in terms of how that applies to temporary foreign workers, there really isn't much of a difference. And you'll see as we move through all of these topics, the law kind of says that temporary foreign workers are going to be governed by provincial labor and employment laws. So the same kind of rules that apply to your other employees should, subject to certain kind of immigration constraints or compliance constraints, they should apply to temporary foreign workers in the same way. So I'll note, kind of make a note where there may be a difference, but for the most part, we're dealing with similar issues. And in terms of the reduction in hours, again, it's the same kind of risk that you have with the compensation reduction, right? So you want to be operating within that kind of range of 10 to 15%. Once you move beyond that, you start having a higher risk of a constructive dismissal claim. And then kind of beyond the reductions in hours or the reduction in salary is what I mentioned before, which are the layoffs. And obviously that's something that's come up a lot for employers across the province and across the country. So what's really kind of important to keep in mind, and something that's often forgotten in the context of COVID when everyone's talking about layoffs, is that there's not actually any common law right to temporarily lay off employees. So these rights are set out in minimum standards legislation. So in Ontario, we're talking about the Employment Standards Act. Federally, we'd be talking about the Canada Labour Code. And then in other provinces, we'd be talking about corresponding minimum standards legislation. But if you don't have language in your contract of employment or your collective agreement that provides for layoff, temporarily laying off your employees comes with a risk of constructive dismissal. Despite that, you do see a lot of people who are still kind of engaging in layoffs, even without that language. And there has been kind of a general feeling that in the context of COVID-19, constructive dismissal claims may go down as people will want to retain their employment when all of this ends. But it is something that you kind of need to factor in as a risk factor when you're dealing with all of this. There's also some potential defenses to constructive dismissal claims that come up with COVID. The most common one, and one you may have heard your labor or employment lawyer mention to you, is the whole idea of the doctrine of frustration of contract, right? So essentially, unforeseen circumstances outside the control of the employer have made the terms and conditions of your employment impossible to implement, right? So essentially what we would be saying is COVID-19 has created a circumstance in which it's no longer possible for us to continue to employ you, or no longer possible for us to continue to have you at work, and so we're temporarily laying you off as a result of that. We haven't actually seen these cases litigated yet because we're still kind of, I guess, at the beginning of this. I don't know. I feel like that's probably jinxing it, but we're at the point where we haven't really seen the cases play out, so we don't know how those defenses will end up playing, but that is a possible option that's open in these circumstances. So in terms of what an actual temporary layoff means, assuming we're talking about the minimum standards version of temporary layoffs, in the Employment Standards Act in Ontario, it's set out, the rules for temporary layoff are set out at section 56, subsection 2 of the legislation. And essentially what it says is that a layoff of more than 13 weeks in any period of 20 consecutive weeks is going to be considered a deemed termination. So essentially what that means is that if you were to lay someone off now, 13 weeks later, they would be considered deemed terminated, and then you would subsequently owe them their termination and potentially their severance entitlements under the ESA. That doesn't account for the frustration of contract argument, in which case you wouldn't owe those notice entitlements. But just kind of on a baseline understanding of temporary layoff, that's when it would be triggered. There's also options to lengthen layoff periods. So the ESA says that if you are willing to continue payment of certain benefits or pension contributions, you could extend the layoff to 35 weeks within a 52-week period. You could also get written agreement of the employee to extend to that period. So essentially, again, that just gives you more time to kind of deal with your staffing problems and have employees off without subsequently dealing with the deemed termination side of all of this. One of the things that we were talking about kind of before this is, okay, well, what happens if you lay off an individual who's on, who's a temporary foreign worker, and there's additional kind of costs that have been associated with them coming into Canada or now being in Canada, or relocation expenses or things like that. And from a pure employment standards perspective, there's no increased kind of termination cost that would correspond to that. If an individual was temporarily laid off and subsequently brought a claim of constructive dismissal, you may be dealing with a situation of increased damages claims, right? So the individual may claim aggravated or punitive damages, or may claim damages relating to their relocation costs. And so that's kind of where that would factor in. But from a pure legal minimum standards perspective, again, the same provincial laws would apply to your temporary foreign workers. Obviously, because these are provincial employment laws, it would change based on the province that you're actually in, right? So Alberta, Manitoba, Saskatchewan would have different laws. There are some provinces that have specifically changed their layoff laws in response to COVID-19. So Manitoba is kind of the most notable example. They've essentially said that periods of temporary layoff during the declared emergency period will not count towards that kind of ticking time bomb towards deemed termination. So essentially, you can lay off an employee in Manitoba during this the declared emergency period without starting to move towards a deemed termination, which is very helpful for employers out there. So if any of you are from Manitoba, congratulations. And obviously under the CLC, the rules are going to be different as well. And so there's legislation there that essentially says that a termination or a layoff will become a deemed termination at 3 months. And there's options to extend the layoff period under the CLC as well. And obviously, I guess the step kind of beyond layoff would be potential consideration of termination. And I won't go through all of that because I would assume that most people probably aren't at that point. But if you are, again, you would be dealing with potential minimum standards for termination, or you may be dealing with reasonable notice at common law, or you may be dealing with specific provisions in your employment contract. And what kind of governs entitlements on termination is going to be based on what your employment contract sets out. So if you have nothing in your employment contract, you're dealing with reasonable notice. Or if you have an ESA only provision, you would be dealing with those entitlements. If you're dealing with a termination of contract, you may again have the option of frustration arguments open to you. In the context of temporary foreign workers, that argument may actually be heightened because, for example, you could have a situation in which an employee is required to return to their home country or is restricted from actually entering into the country. And then it's much easier to argue, well, not much easier, but easier to argue that there's a potential frustration of contract that's outside of your control because essentially this person has been restricted from actually kind of coming to work for you. And then another question that's come up that myself and Valerie and Stephen were talking about before is, okay, well, what happens if you terminate someone and then they can't actually go home, right? So they're restricted from leaving the country after the period of termination. From a purely legal perspective, if you terminate an employee, you don't continue to have obligations to them, right? At that point, your kind of obligations to them are severed. There may be, again, a situation in which an employee would subsequently bring a claim relating to that termination and may claim additional damages as a result of the fact that they then had to remain in Canada and couldn't leave and costs associated with that. But from a kind of purely legal perspective, it doesn't necessarily change what you would do on termination. Obviously, there's also kind of public relations things that you would be considering in those cases. There's a lot of attention and kind of public scrutiny on employers at this time, and a lot of expectation that employers are going to work to keep employees at work and paid to the extent that they can. So a situation in which employees are being terminated when they can't go home and are going to be without money is a potential kind of public relations thing that you would want to consider. So I think in that case, if that's a situation that you're dealing with, it'd be a great opportunity to kind of contact your labor and employment lawyer and talk about options for maybe a more moderate response or how you would kind of manage that. And I'll pass it back to Valerie to talk a little bit about the immigration sides of the reduction in hours and pay and layoffs. Thanks.
Thank you, Amanda. So essentially, when you have your LMIA or your LMIA exempt work permit, you've, as an employer, agreed to respecting a set of terms and conditions, which include hours and salary and location of employment and job duties. So obviously, any reductions to hours or pay is a great concern and does potentially put you in a position where you could be deemed to be non-compliant in the context of an inspection. So one of the things that's important to consider is this is obviously a new situation that hasn't really been dealt with before in the compliance context. But as we discussed earlier, when companies are found to be non-compliant, there are justifications that can be used. And so even if the company may be non-compliant, perhaps there's a legitimate reason for that non-compliance. And there are justifications for significant economic situations which are completely beyond the employer's control, and in which the employer acted in a way where they treated the temporary foreign worker and the Canadian worker in a similar manner. So Amanda had spoken about differential treatment and how that would be important from, to avoid that from an employment perspective. It also would be important from an immigration perspective, because if you're trying to argue that there was no choice and salaries had to be reduced, if the temporary foreign worker salary is reduced by more than the Canadian workers in the same position, that would be hugely problematic in a context of an inspection. Now, for workers who are on LMIAs, when the employer is applying for the LMIA and is issued the LMIA, they are agreeing to notifying the government of changes to conditions of employment. And that would normally include things like layoffs and terminations, but it also would include things like salary changes and changes to the role. So this is, of course, a very new and unique situation. And it's the type of situation that we would want to look at on a case-by-case basis to look at the best way to comply with that requirement in light of the situation of that particular company. It's a little bit different under the International Mobility Program, so individuals on intercompany transfers, because there's that obligation doesn't exist to the same extent, and there's no real mechanism to advise of changes. But that being said, there's still the same obligations in terms of paying the employee what was promised is still there. So there are a number of issues here in terms of pay and hours and changing the role. Of course, this is a new situation, and there are justifications that can be used if necessary. But it's this kind of thing that we would want to look at on a case-by-case basis to look at the wider context and see, you know, what's happening with the company and other workers, to look at the best strategy to deal with those potential compliance issues. And for layoffs, it is something that would generally be, you would notify Service Canada, and there's no, you know, there's nothing really different about layoffs for foreign workers. In the International Mobility Program for intercompany transfers, it's not something that normally you would notify the government about. So it's really something for the labor market impact assessment workers, where that would be important.
So kind of moving on to the next piece, and that deals with the rescission and delays of start dates due to COVID. So kind of separate and apart from the reduction of hours and pay and layoffs. And actually, I just want to go back on one piece, because someone I think had asked a clarifying question on the reduction of hours, and I just wanted to answer that before we kind of move on and I forget about it. So I had talked about the kind of limit for constructive dismissal claims, and I had said 10 to 15%. That doesn't mean that any reduction below 10 to 15% is 100% not a constructive dismissal claim, but it does mean that the case law is on our side in kind of dealing with those issues. So if you are going to do a reduction of hours or a reduction in compensation, you should be looking at a threshold of around 10 to 15%. Anything above that carries with it a higher risk of constructive dismissal. So kind of getting back to the topic at hand, the rescission of contract and delays of start dates. So this is something that's come up a lot in the context of kind of workers in general, because a lot of people, particularly if you have people who are coming in for certain seasonal work or for summer work or things like that, you may be in a position in which you currently cannot kind of sustain that work, or your business is closed, or you're not an essential workplace, or things like that. And these employees are really no longer necessary. And so with both the rescission of contract and the delay of contract, you're really kind of dealing with the same risk that we talked about before. So essentially, in this case, the person would claim a potential damages as a result of a breach of contract. And so the kind of playing out the rationale there, an employee would claim that they were offered a job, and as a result of that offer, they either gave up their alternate employment that they previously had or stopped looking for other jobs. And as a result of that, they're entitled to damages for the breach of contract of no longer having the employment that they said that they were entitled to. In the case of temporary foreign workers, if there's a rescission of a contract or a delay of a contract, again, doesn't necessarily change the actual kind of damages associated with the constructive dismissal from a purely termination standpoint, but there may be additional claims for damages as a result of relocation costs or potential kind of egregious impacts on those individuals that wouldn't be felt by people who are already in Canada or who have more of a kind of support network set up in Canada. So that's something to keep in mind. In the case of a rescission of contract and a delay of contract, again, we would deal with the same kind of defenses. So we would be dealing with the potential defense of a frustration of contract. Again, it's not entirely clear to us exactly how these defenses are going to play out. And you would have to show that there's unforeseen circumstances that are out of your control and that resulted in you kind of making it impossible for you to start the contract at the time that you had previously indicated you would, or to start the contract at all. An important thing to keep in mind with kind of frustration cases, and again, if you're going to be dealing with a frustration defense, you should probably be dealing with a lawyer while you do that. But generally, frustration isn't going to be made out just by virtue of the fact that there's monetary issues, right? So you can't simply say, oh, well, we're going to lose money if we hire this person. It's much harder to say that that actually is an unforeseen kind of impossible circumstance that's been imposed on an employee. In the unionized context, if anyone's operating with unionized employees, kind of delays or rescissions of contract, the considerations are a little bit different. In that case, you're kind of dealing with the issue of whether or not a union has the ability to grieve when an employee hasn't actually started working. And that's going to be highly dependent on the specific language of any given collective agreement. And so I can't add more to that other than to say, look at the specific language of your collective agreement, which is the answer anytime we talk about unionized employees. And then from a delay of contract perspective, like I said, I mean, I've grouped them kind of together because the implications are really the same, but the risk with a delay is less, right? Because the kind of implication with that is that the person is eventually going to actually start working for you. And kind of, I guess, a corresponding thing that comes with that is if they eventually start working for you and they bring a claim of constructive dismissal, which says that they have lost their job, and they had the opportunity to what we call mitigate those damages by keeping their employment with you, that's kind of another thing that comes in that may reduce damages on the delay side, which isn't as available on the rescission side. So those are some of the factors that come into with that, and I'll pass it over to Valerie to comment on that from an immigration perspective.
Thank you, Amanda. So a couple of, just an important update in terms of which affects delaying employment. So LMIAs are normally issued for 6 months. So generally speaking, when the company's issued an LMIA, the foreign worker has 6 months to apply for the work permit. Given the current situation, they're now extending it to 9 months. So that does give you more time to plan, and if you need more time to bring the person here, that should assist with that as well. In terms of the work permit, if the person's been approved from outside of Canada, they'll have an expiration date to use that approval by. So generally speaking, it's tied to the duration of their work permit, and it's usually a significant amount of time. So if adjustments need to be made because of the situation to bring them in at a later date, there is a possibility to look at that approval date and see if changes can be made. There are no really other particular immigration issues, I would say, with this point, except the fact that keep in mind that if you are making the decision to bring the foreign worker to Canada, they will need to self-isolate for 14 days, and you will need to pay them for that period. So you can't delay their employment when they arrive. You can't not pay them when they arrive. When they arrive, they will need to go on payroll and they will need to be paid appropriately. So there's a lot of planning required, and it's important that you're part of that planning, because for a foreign worker that may not have a network here, they may need the employer's assistance to have groceries delivered or things like that. And that'll be very important in terms of their ability to enter and satisfy the officer when they enter that there are mechanisms in place to help them fulfill their 14 days.
I also would make the point that you may have the LMIA, you may be approved by the embassy abroad, and you've got that letter that permits you to ask the border service officer for your work permit. But until you actually enter Canada and use that document, none of the compliance applies to you. So it's when you actually have that work permit. So if someone is outside of Canada because they can't even get a flight because the airlines are closed down, or their country won't let them leave because of their process of keeping people around, the compliance does not apply to you until you actually have a work permit in your hand. And also, the federal government is assisting people that come into Canada as new workers, or people that need their social insurance numbers extended based on their old work permit had expired and they've now got a new one. This can all be done online. Before, they never permitted it. So again, that was a big issue with a lot of employers, because temporary foreign workers have SIN numbers that expire. So now you can go ahead and extend that and also get them online.
So the next thing that we're going to talk about is the statutory leaves of absence. I'm like scanning through the questions as we're doing it. So just as a kind of go back, someone had asked about the section of the CLC that sets out the temporary layoff of 3 months. So that is under section 30 of the, it's set out in section 30 of the Canada Labor Standards Regulation. So if that person needs me to actually send it to them afterwards, just send me an email, but I just wanted to say that kind of quickly. So statutory leaves of absence, you guys hopefully have kind of heard of these. There's two main ones that have come up in the context of COVID-19. So both of them in the ESA, so talking about Ontario now, are under section 50.1 of the Employment Standards legislation. So on, we have the declared emergency leave, which was previously in existence and has now been triggered with the declaration of an emergency in Ontario. And then we have the new leave, which is called the infectious disease emergency leave, which just rolls off the tongue, which the province introduced in light of COVID-19. So the two leaves are different, but somewhat similar. For the declared emergency leave, like I said, it would last for the period of time of the declared emergency. The infectious disease emergency leave lasts as long as the disease, which is in this case COVID-19, remains designated by regulation, and the employee is unable to work because of their circumstances. And so there's specific eligibility requirements for both the DEL and the IDEL. For the DEL, usually it's the person is out of work as a result of the declared emergency. And the other kind of triggering condition is if an employee has childcare obligations that arise as a result of COVID. So in Ontario, for example, daycares are closed. There's individuals who are required to stay home and take care of their kids. And that could potentially trigger the declared emergency leave entitlements. The IDEL has the same thing. So if you have childcare obligations, you may be similarly entitled to the IDEL. But the IDEL also has kind of expanded categories. So for example, if you are on quarantine, you may be entitled to the IDEL. Obviously for temporary foreign workers, that would be a little bit different because there's obligations to pay individuals. So they likely wouldn't be on the kind of same unpaid job protected leave. There would be situations in which you have to care for someone else who may be sick. And the most kind of notable one for the purposes of this situation is that the IDEL would apply if an individual is restricted from returning to the country as a result of travel restrictions. So one of the things that you may be considering in terms of dealing with temporary foreign workers who, for example, are restricted from coming into Canada, who were previously planned to and are not able to, and Valerie will correct me if the immigration side of this tells me I'm wrong, but you could have a situation in which you would bring an employee on and put them on an infectious disease emergency leave. And so there's a couple considerations that would go into that, right? So from one perspective, if you are not delaying the start of a contract, you reduce the risk of a constructive dismissal claim, right? Because you've actually hired the person, you just put them on a job protected leave. But the kind of side point of that is then you also have a clock that's ticking on their employment, right? So again, I will leave it to Valerie to correct me if I'm wrong, or to Stephen to correct me if I'm wrong, and I may be, but that's definitely, they're both looking up. That's definitely a consideration that you could potentially be discussing probably with both your immigration lawyer and your employment lawyer. So the other things to keep in mind in terms of the DEL and the IDEL, both of them are job protected leaves. Essentially what that means is that employees can be terminated when they're off on the leave. There's also a requirement to continue benefits during the period of the leave. I think one of the other questions that had kind of popped up in my peripheral vision as we were talking about this is someone asking about the difference between benefit and continuation while people are on layoff versus circumstances where people are on kind of job protected leaves. And so generally the difference is that if an individual is on a layoff, subject to specific language in a collective agreement that provides otherwise, or specific language in an employment contract that provides otherwise, you're not required to continue benefits for the period of temporary layoff. In contrast, if a person is on a job protected leave, you would be required to continue benefits during that period of time. And so that's kind of the big distinction, and a lot of the reason why people kind of sometimes opt for the declared emergency leave over the temporary layoff. And I think that's my kind of piece on the leave. So I'll pass it back over to Valerie to maybe correct me, but also to add more.
So, I mean, I think for this infectious disease leave, if it would take effect immediately, there could be issues with the new compliance requirements. I think we'd need to look at it and detail with the employer to see what the plan would be, because as soon as the work, and this is like a question that I see coming up, basically as soon as the work permit's activated at the border, the employer is on the hook for those 14 days. So I know there's a question about whether someone can quarantine first and then have a start date beyond that, but the employer will enter the compliance regime as soon as the worker activates that work permit. They'll be in the system, and so they can conduct a review on you basically as soon as that individual does cross the border and has their work permit in hand. And if it's an LMIA, you actually have to advise Service Canada when the person is entered.
Right. And it's important to understand too that this obligation to satisfy compliance goes on for 6 years. So it's really important that if you are a large company, that you have a compliance officer that will be able to have copies of the documents, proof that you did pay that person that was in quarantine for the 2 weeks.
It's very, I mean, under normal circumstances, the person's start date may not be when they arrive, but the inspections can start from their arrival date. And if they didn't start on that date, then we have to provide some explanations, and there may be reasonable explanations. But this new 14-day requirement changes that, because now as of day one in Canada, they do have to be paid substantially the same wages. And so there isn't wiggle room to delay the start date by 3 weeks because, you know, they want to look for housing or whatever the situation may be, because they're you know, immediately expected to be paid by the company. One thing I would just mention about leaves, just to be aware of, if you have employees who are trying to accumulate Canadian work experience for permanent residence, so if they are on a leave or they're temporarily laid off, just to be aware that that time period where they're not performing the duties of their work will not count towards their Canadian work experience if they're trying to accumulate that Canadian work experience for permanent residence purposes. So just something to be aware of if they're working toward that any leave, and this is just even, you know, a typical leaves like a parental leave or being laid off temporarily on EI would basically, there'd be a gap in their work experience for permanent residence.
Thank you. And so I think the last two topics that we had talked about, or I guess 3 topics, is the Canada Emergency Response Benefit and the Federal Wage Subsidy. And I won't go into too much detail in terms of what all of those things are, because they're overly technical, and a lot of the online resources actually set them out better than I can tell them to you. But as far as we can kind of tell, and subject to specific kind of exceptional circumstances, temporary foreign workers would be entitled to the Canada Emergency Response Benefit, and they would also be employees who would entitle employers to the wage subsidy. So for the Canada Emergency Response Benefit, essentially, if you meet the eligibility requirements for the benefit, you would receive $500 per week to a maximum of 16 weeks, and the individual would be entitled to this $500 regardless of what they would be entitled to EI. And the important thing to remember with the CERB and with EI is that the government has kind of streamlined the process. So if you were on EI before March 15th, 2020, you would kind of continue on EI. But now if you're kind of post that time and you're off work either as a result of layoff, or you would be entitled to EI regular or sickness benefits, or you're off work, sorry, as a result of COVID-19, you would be kind of streamlined into the CERB process. And so applications for EI really aren't happening now. Everyone is really kind of going into the CERB. And so that's something to kind of keep in mind. As I said, it's the government has kind of indicated that individuals who are residing in Canada would be entitled to the CERB, so you don't necessarily have to be a citizen. The other important thing to kind of keep in mind is one of the requirements in order to kind of get entitlement to CERB is that you have to have earned $5,000 from either employment or self-employment in the 12 months prior to your application date. And the government has also been clear that you don't necessarily need to earn those $5,000 in Canada. So in kind of an exceptional circumstance in which an individual comes over to Canada on a temporary foreign worker who comes into Canada and subsequently is laid off and doesn't earn $5,000 in the time before their layoff, doesn't necessarily mean that they'd be disentitled to CERB entitlements if back home they had earned amounts equivalent to 5,000 Canadian dollars within the past 12 months. So those are kind of important things to keep in mind. And then in terms of the federal wage subsidy, that one's a little bit more complex, and we're still kind of, I think we're waiting for regulations from the federal government to come out to provide more information about the subsidy, because there's still a lot of unknowns that come with it. But essentially the point of the program is to minimize layoffs and to kind of promote the rehiring of employees. And essentially what the program does is it provides a payment directly to employers, who qualify for it. So if an employer qualifies, the amount of the subsidy is 75% of employees' kind of remuneration, up to $847 per week per eligible employee for a period of 12 weeks. And so the period is from March 15th to June 6th. The payment would be made directly to the employer, who subsequently makes the payment, which is the wages, to their employees. And a good way to kind of think of it is by way of an example. So if you have an employee who earns $800 a week, the employer would be eligible to receive a wage subsidy, assuming they're eligible for the program, of up to $600 for wages paid to that employee. And this is equal to 75% of the subsidy during the period of annualized earnings, up to a total of $58,700. So again, all this information is online, and it's overly technical and difficult to kind of explain over a webinar, but that's kind of a simplistic explanation of what's going on. The government has also indicated that eligible employee status is going to be determined based on where the individual is employed, not where the individual resides, which means that, or we take that to mean that temporary foreign workers would be entitled to be employees who trigger the subsidy for their employers. It may be different where an individual is employed by a Canadian entity, but is actually working outside of Canada. It's not entirely clear that those people would satisfy the eligibility requirements, and we have a tendency to think that they would probably be on the side of not being eligible for the wage subsidy. And just kind of as a last point on this, in order for employers to be eligible for the subsidy, it's kind of a two-step process. So first, you have to meet the definition of an eligible entity, which is a pretty broad definition. The groups that are specifically excluded are certain public sector employees. So that would include municipalities, school boards, hospitals and universities, and colleges. So those employers wouldn't be eligible for the wage subsidy, subject again to further regulations that we hear on this. And then the next step is determining whether or not you qualify for the subsidy. So you will qualify if you experienced a 15% reduction in revenues in March of 2020 compared to either your revenues in March of 2019 or the average of January and February of 2020. For April and May of 2020, which is the second kind of two periods where you may be eligible for the wage subsidy, the drop in revenue must be at least 30%. There are a bunch of technical details around accounting methods to be used by an employer in figuring out whether or not they actually have kind of triggered this entitlement, and that would require kind of consultation with your accountants and things like that, but that's kind of the baseline understanding of when you would kind of be in a situation in which you'd be triggering an entitlement to the wage subsidy. The other important kind of thing to keep in mind is that you have to use the subsidy to pay wages to employees. The government has been very clear that employers are supposed to be doing their part to be using the subsidy in a manner that helps employee well-being. And like I said before, the goal of all of this is to actually have people kind of come back. They've also said that employers should be using their best efforts to top up employees to what their what they call pre-crisis level was. We're not exactly clear on what best efforts mean at this point, but in order to kind of ensure that you're complying with that, you should be keeping records of all of your efforts to kind of bring employees back and to top up wages, as the government has indicated that CRA would have the ability to enforce this program. And so you want to ensure that you're prepared in the case of an audit or something along those lines. And so I'll pass it over to Valerie to make final comments, and then I assume we will address some of the questions in the corner.
Yeah, I don't think I have any particular comments on the programs. I don't know if Stephen, if you did.
Nope, I think it was really a labor issue.
Very comprehensive, yeah. And I know that we do have a number of questions. So I see a few work permit kind of immigration questions that I might merge together just to make the most use of our time. So I see some questions that are kind of popping up that are interconnected. So maybe I'll start off with one immigration related question. So there's a question about disclosing changes for LMIAs versus and then someone else asked about non-LMIAs. So when you have individuals who are not on LMIAs, there's no real mechanism to update immigration. There are circumstances where you need a new work permit. So if the conditions have changed substantially, you may need a new work permit, and that's where we would want to look at it on a case-by-case basis. There was a question about how could you change the wage because it's tied to the NOC code and prevailing wage. And technically you can't reduce wages. I mean, that's the reality of the legislation. You can't reduce wages. So the question becomes if you do reduce wages and you're faced with compliance issues, looking at whether there's a reasonable justification. But certainly you can't normally, and we sometimes, we'd have to look at getting a new work permit depending on the situation and the changes, and if the role is going to be different and all that. With LMIAs, you do have an obligation to report. You have an obligation to report changes to conditions, layoffs, if someone quits their job, if you terminate them. Service Canada expects that you report these things to them. I think given the complexities around the compliance issues, if there are reductions to wage and hours, it's the kind of thing that we would really suggest that you review with a lawyer. You can contact us to look at what the implications would be and how the best way to do this to minimize compliance risk to the company. So if you are facing these issues, if you're facing possible changes, please reach out to us, and it's something we can discuss and look at and see the best path forward to protect you. Maybe Amanda, I don't know if you want to take an employment question. We can kind of go back and forth. I think maybe she's frozen. There was a general question about processing. So what's happening during this period of time? Is the government still processing PR applications, work permits, LMIAs? And the answer is yes. They are still processing all of these applications. We can expect to see some delays. One particular delay that you might see, if the applicant is required to complete biometrics as a part of the process, they will see a delay because it's currently difficult to complete your biometrics in most countries of the world, including Canada and the US. So most biometric collection centers have temporarily closed. There are some exceptions. So in some countries, they are still open. The government is not going to penalize anybody because they can't get their biometrics done. They're not going to refuse the application for that reason. They're allowing people more time to do that. But if you do need biometrics, if your employee needs biometrics, it may mean that there is a delay in processing because we'll have to wait until they're able to do their biometrics for the application to continue.
And that's why there's an advantage for some people that are currently in the United States that are eligible to apply for their work permit at a border. They can do their biometrics at the border. But if you look at the ban, it talks about, people outside of the United States. Those people are prohibited because the government has indicated that anyone that is eligible for a work permit that is not in the United States must apply online at the embassy before they come. So again, it's, it really matters where you are and do you have access to the United States, because there are some great advantages with respect to processing of temporary documents.
Mm-hmm. There were some questions about changing status once the person is in Canada, and whether, if they're on a particular 120-day work permit, and normally that can't be extended, what can be done? So nothing has really changed in that respect. Whatever categories existed are still there. If you didn't qualify for something before that, that's not going to change. Extensions can still be processed from within Canada. There was a question about restorations. Restorations can still be processed from inside of Canada as long as the person meets the requirements of the category that you're applying under. So that is still there, and there's still that obligation to remain in valid status. The government isn't allowing, there's no, special exceptions because of COVID-19. The obligation for the person to remain in valid status is still present, and there are no exceptions right now.
So I guess the last question we'll take deals with the provincial nominee programs and employees and employers in those situations. Currently in the province of Ontario, they are reviewing, and they have not come out with any firm policy with respect to if someone is put on a temporary layoff, what do you do? If the wages have changed, what do you do? So we're waiting to see how the province of Ontario is going to react to that. Some of the other provinces have been a little more proactive, where in British Columbia, there are certain obligations that they have indicated during COVID-19 that must be done. Alberta just came out with some information indicating how their provincial nominee program is changing under this. So again, we go ahead and we advise you just watch for the announcements and changes under the provincial nominees that are going to be included. So I guess on that final question, we thank everyone. Please stay safe. We encourage you to contact Amanda if you have any labor issues. Certainly contact us with respect to immigration issues. And so there's lots of issues that are out there. It's very, very fluid, and you've got to really be up on what the government of Canada is doing to protect us during these interesting and difficult times. And Amanda, do you have anything else to add, or you're good? I guess we're good. So thank you, everyone.
Thank you.
Be safe.